you have been moving in that direction, that family members should be covered. Well, I just want to point out two cases to you that cut against that argument. In Galbert versus the City of Miami Beach, the City of Miami Beach took the position that the son-in-law of a sitting commissioner could not be appointed to the Board of Adjustment based on the state's nepotism law. Although the 3rd District agreed with that, the Florida Supreme Court reversed it and said, this is a penal statute, and you cannot add words to it. You can't make implications. It is a penal statute that must be strictly construed, as your code must be. In Mandelstam versus the City of South Miami, the city had a request to have a gymnasium built in a residential neighborhood. The code said that was an accessory use. But accessory use means that it has to be accessory to something. The city took the position that because it wasn't accessory to anything, that it couldn't happen. The 3rd District said, no, your code says what it says. You can't add words to your code that, that's not what it meant. And if nothing is ambiguous, then you just have to read the law as written. In the Miami Beach case, after that Supreme Court opinion came down, the city successfully accomplished having the legislature amend that statute to cover that situation, that merely recusing yourself from the vote doesn't allow the son-in-law to be appointed. So I recognize that you have a problem thinking that, well, if it went to the wife, it really went to the commissioner, and so it should be a gift. But your code doesn't allow it.
Can I interrupt you?
Of course you can.
So on November 27th, you say, I'm reading on page 25, line 23, and as far as Mrs. Sarnoff goes, again, yes, it's a gift. Yes, your opinion in the North Miami case indicates that.
Okay. And I have changed...
Why is that not a concession?
And I have changed my mind. And I'm allowed to do that.
Okay.
And courts...
I just want to be clear about what that...
Right. I freely admitted in the last document I submitted to you that I said it, and I've now changed my mind about it. And I've changed my mind about it after reviewing the Miami Beach case. So, in that case, and in that order, you said, well, it's not really clear, and so we're not going to make any bright line determination. In fact, at that hearing, it was Ms. Addy who said, well, we didn't find that was a gift because it was a huge factor in learning what the wife did on that trip. A review of that Miami Beach transcript will show exactly what the wives did and why the city said, we don't have to, why the city's position was you didn't have to declare that as a gift. Okay? They said, it's a nice idea that wives accompany commissioners because it shows how serious the city is about the city business it's undertaking. The argument was, that's exactly what it said. The argument was, well, that's what the city's been doing. As to what the wife actually did, they went to dinner and they stood by the information booth. That's exactly what they did. Now, that's part one of my argument. Part two is the following. Let's say that the Visitors and Convention Bureau went to Mrs. Sarnoff and said, we want to have Budapest as a sister city, and we know how fluent you are in Hungarian. So we're going to ship you over to Hungary, and you're going to act on our behalf, and we're going to pay you for that. And that happens. And the commissioner doesn't go with it. You don't have jurisdiction over her.
Mr. DeLoy, you're talking about counterfactuals. In your brief, you seem to suggest that there is something significant about the fact that we never inquired with respect to what Mrs. Sarnoff did on this trip. And I would suggest that it was unnecessary because you conceded that it was a gift.
And now that I've changed my mind...
But now that you've changed your mind, you can't, it seems to me, suggest that the absence of any factual determination of what Mrs. Sarnoff did has any significance.
I'm not. I'm asking for Mr. Sarnoff to now come up and tell you what Mrs. Sarnoff did in regard to city
That
business.
is to suggest that you want to relitigate this issue again. That's exactly, it seems to me, what you're saying.
If that's what I'm saying, that's what I'm saying. I'm not asking to relitigate it. I'm asking you to hear testimony that was a huge factor in Miss Addie's vote and in your consideration of this. And if Miss Addie disagrees with what I just said, please tell me. But
Commissioner Addie might respond.
Mr. Chairman,
I've seen
I'm sorry
no
that you're
evidence as
upset
far
about...
as agendas or anything that showed her name on a program or anything that relates to her having any kind of formal kinds of responsibilities in this case, which was just the opposite in the Miami Beach case, where there were formalities for those wives. So,
But there
Miss
were...
Addie has not changed her mind.
No,
on this.
I'm not asking you to. I'm simply saying that you said that that was a huge factor. I asked if you wanted to hear. You correctly have now said, well, no, because I admitted it. Well, I'm changing my mind, and I'm asking the Commission to hear briefly from Mr. Sarnoff about what she did. And that is still just part of my argument. I don't believe you have jurisdiction over her.
No, can I just clarify? No one is attempting to exercise jurisdiction over Mrs. Sarnoff. There's no complaint against Mrs. Sarnoff. There's no final order against Mrs. Sarnoff. There's no letter of instruction against Mrs. Sarnoff. We only have jurisdiction over Mr. Sarnoff. Like the State of Florida Ethics Commission decided in the Miami Beach case that the city of Miami Beach sent up to them, they even said, we don't have jurisdiction over this official's wife. We have jurisdiction over the official. And when the city sends his wife with him on this trip, because as matters of protocol, she needs to go to dinners with him, she needs to be seen with him, they're considering that a gift to the elected official, just like it is in this case. Unless Mr. Sarnoff is going to get up here and say that his wife did nothing but sit by the pool and sun herself while he went out and did all the work that he needed to do for the Greater Miami Visitors Convention Bureau, and she accompanied on him on no part of that, no dinners with officials, she didn't meet anybody. Unless he's prepared to say that, he's got no argument to make. And my recollection is when he was standing here in November, he was saying that she was very involved, that somehow this was part of the official nature of the trip, that they were trying to write it off as being an official business trip that was excusable. The simple fact is, the way we interpret our ordinance since the Miami Beach case, our existing ordinance, which doesn't require an amendment, doesn't require a new ordinance, our code is now being interpreted as if this is a gift to the wife that you are the beneficiary of, because really, Mr. Sarnoff, you're the beneficiary of having your wife take this trip with you, then it's a gift to you, and you need to respond. That's the bottom line.
Mr. Chairman, members of the Commission, I guess this is our 5th time being here, and it's not a usual spot for me to be, but I thought I'd put a little meat on the bones of the issue, because you hear a snippet.
Forget the rhetoric and just get to the point at this time, because every time somebody moves up here, it goes back to November of 2012. It's getting close to July of 2013. It's well past time for this to be finished, and I know I skipped a month of June. I did it on purpose.
Well, I can tell you that part and parcel of the conversation with the city attorney was the disclosure that my wife would be attending. And the city attorney said to me, just be sure that she attends every meeting that you go to and that she engages in whatever follow-up work you're going to do. My wife happens to be my paralegal of 18 years. And as such, she set up the meetings in Sao Paulo, she set up the meetings in the other part of Brazil, in Itajaí. She was with me at all times on all Volvo functions. She then followed up with everyone that we met and gave personal thank yous to everybody, and then suggested a sister city initiative. As such, that sister city initiative is live and well in the city of Miami. Itajaí will be a sister city with the city of Miami, but what I learned in Brazil, which I would have liked to have said something, Judge, was it requires a visa. And believe it or not, Mayor Bellini from Itajaí is having difficulty getting a visa to the United States to accept the sister city initiative between the city of Miami and Itajaí. And while you may think the city of Miami has a lot of sister cities, we actually only have 5. So Itajaí will be the 6th sister city. But it was my wife who actually created the sister city initiative, followed up by the mayor's office to put forward that. And I just want to give one last suggestion. I had no intentions of going to Brazil. It was not my role or function to go to Brazil. It was a mayor's function to go to Brazil. And the mayor was pretty silent up until around April 1st as to whether he was going. On April 1st, we actually got through a third person that the mayor did not want to go. So I then had about 14 days to get together a trip to Brazil. The person that put that trip together happened to have been my paralegal of 18 years, who's put me on many trips on many different occasions, was the person charged with getting the visa to us. And by the way, getting a visa to Brazil in 14 days is no small feat. And if we were not in the place that we're in right now with the federal government with visas, because back then it was a 6-week process. So she did everything, including getting us to Brazil, attending every meeting in Brazil, in Sao Paulo, in, I forgot the other city we were in, Rio de Janeiro, where we met with the Olympic Committee, where we met with the World Cup folks, and she followed up with the Itajaí folks to create the Sister City Initiative in Miami. We have the emails commensurate with that. And that's what she did, and that was a normal day in Teresa's life. And she has never sat on the beach in Brazil, nor did I sit on the beach in Brazil. If you look at the schedule, there was never time to sit on the beach. There was never time to do anything other than attend every meeting. Thank you.
And I just thank the Commissioner for making my case. Essentially, she was there to be his right-hand man, person, and so it was a gift to him. The reason that she was going, that her trip was paid for, was so that he could have his paralegal of 14 years, his executive assistant, his trusted companion, go on this trip with him and be involved in every part of the agenda. That's the same thing as the Miami Beach
That's
case.
what keeps confusing me, and maybe I'm bouncing off the wrong walls, but it seems to me if Mrs. Sarnoff went to Brazil and worked for the city of Miami, that it's not a gift. It seems to me if Mrs. Sarnoff went to Brazil and sat by the pool every day and drank caipirinhas and enjoyed the sun and the music and everything else in Brazil, then it would be a gift. So
The important thing is it wasn't paid for by the city of Miami. It was paid for by a third-party private entity, which is not the city. Had the city paid, in fact, had the city paid for her to go, under the decision from the Florida Ethics Commission, he would have had to declare it as a gift because the city paid for it. We're just, delete the city, stick in third-party beneficiary, Greater Miami Visitors Bureau, same scenario. Third-party beneficiary paid for the two of them to go on the trip. It's the gift is to him, not to her.
Mr. Murowski said a couple of minutes ago, you have no jurisdiction over Mrs. Sarnoff. You know, and your code doesn't allow you to. It's not enough to move in that direction.
This is not your practice.
It's not enough. It's not enough that this is how you're interpreting your code. You can't do that. You cannot get there from here. You have to do exactly what the Supreme Court made us do in the Galpin case, which was to go back and change the law. If you want family members to be covered, then you have family members covered, and you can't say, well, it really was a gift to him. It wasn't. It was a gift to her, and the fact that it was paid for by a private entity makes our case stronger because we were not using city funds Now, what I'm asking you to do is exactly what you did in the Miami Beach case. You issued a final order that said we're not making a determination of probable cause. And we're not even asking you to say there is no probable cause. We're just asking you to issue the same order you did in Miami Beach, and you have already agreed to issue a letter of instruction. Again, I think it's a great idea to change the code to include family members the way the state does. You cannot get there from here as a legal position.
Mr. Crespo, you do not have the right to speak at this proceeding.
You know,
Please be seated.
so much for transparency and ethics. Now,
Mr. Morales.
I'm finished.
Any comments from the commission?
None for me.
Quite frankly, I'm confused about what we're being asked to do in light of the fact that we took a clear vote in November. We, the commission, surely act under the belief that we have jurisdiction. And you seem to concede in November that we did in North Miami. And I think, at least I am, and not speaking on behalf of my fellow commissioners, I am under the belief that we continue to have that jurisdiction. And so my sense is maybe this is something that a court will have to determine. And I will leave that, at least in my opinion, to Commissioner Sarnoff and Mr. De La Gloria to pursue. I am certainly not prepared to declare that we don't have jurisdiction with respect to the gift to Mrs. Sarnoff in this matter. I think it's surely true that were Mrs. Sarnoff anybody else, or many other people, not anybody else, but many other people, we would not care who pays for any trips of spouses or partners. But we do in this case. And we do because we certainly think we have jurisdiction. And we have acted as though we have, and maybe it is up to someone, some higher authority to establish for us that we do not. So that's certainly my position with respect.
Question of clarification. So in December, you approved 2 letters of instruction, and you agreed to remove the words probable cause from them. Do those letters of instruction still stand, or are you coming back with new letters of instruction, or what?
They were approved
In December?
without the words probable cause in them.
So they're being,
So I would assume they still stand.
thank you.
And so I assume that, I just want to be clear about, I assume that there was, that at least part of Mr. De La Gloria's petition was a motion to dismiss for lack of jurisdiction.
That would be my preferred position. But as I said, in order to avoid any type of legal proceeding up on, in order to avoid any appeals of this matter, we are perfectly willing to accept the same order you issued in the Miami Beach case. And in that case, you just said you're not going to rule on probable cause. I would suggest that you don't even issue a final order that says you're dismissing the case or not. Just say that, just recite some facts that happened. Say a letter of instruction is issued. You have the ability to say whatever you want in that final order.
If that's what he's requesting, he's essentially conceding jurisdiction.
No.
Again,
Is he saying issue a final order and issue a letter of instruction, then I'm conceding that you have jurisdiction, because otherwise he wouldn't be arguing that you have no jurisdiction.
okay. I'm trying to make this easy all around. I have not conceded you don't have jurisdiction, okay? So, if you want me to take back what I just said, I'll take it back. You don't have jurisdiction. We're willing to accept an order. You're issuing a letter of instruction without probable cause. It makes no sense to issue an order that says there is.
Let me understand something, because maybe I'm just totally off base here. Didn't we have a hearing and reach an ultimate decision? Why is it that what gives you the authority to come forward now and claim that you had no jurisdiction? My understanding is you're a little late. I mean, tell me why you're not late in making this argument when you had the opportunity. And quite honestly, Mr. Della Gloria, your position here today is perplexing to me, because at one point you said, I take back what I said. I mean, do you mean what you say? Do you say what you mean? I'm a little bit confused, because I don't know what it is that you're saying today. Are you asking for a motion for reconsideration, to have a trial again? I see Ms. Sarnoff isn't here today. I know the commissioner spoke. I'm just not understanding what your position is and what you're asking us to do. If we already had, I'm sorry, let me just finish. If we already had what comes down to a proceeding and there was a decision that was rendered, I think we made a final decision on that. I'm just trying to understand what it is that you're asking for us to do.
Okay. Because I'm allowed to plead in the alternative. After the ruling, you can't confer jurisdiction on yourself. I can't confer jurisdiction on you. It's fundamental error. It doesn't matter what I said. And you know you cannot confer jurisdiction on yourself. So my first position is that we never had jurisdiction over Mrs. Sarnoff, even if I said it 1,000 times.
Even if you didn't bring it up. Even if you didn't bring it up before.
On the tape.
Okay.
Hold on. No.
He's trying to make life easy for you. He's asking you, do you want them to say that your motion to dismiss is denied based on lack of jurisdiction so you can appeal that? That makes life easy. You want easy? They're giving you easy.
Let him speak for himself, Mr. Morawski. We want to get to the crux of it so we can move on. I'm giving him the opportunity to explain himself as to what it is that he wants.
I'll go with that. We won't, however, take an appeal if you issue the order along the lines of the beach order. We don't have to appeal.
So we have before us a motion to dismiss.
Yes.
Think we vote on the motion to dismiss?
No, you have to make it.
Okay.
And nobody's made it.
I move we deny the motion to dismiss.
Second.
We have a motion and a second, denying the motion to dismiss. All in favor, say aye. Aye. Any opposed? No opposed? No abstentions?
Now that
Motion is denied.
And now that you've done that, we would ask that your final order be consistent with your Miami Beach order.
What does that mean?
Yeah.
Are you asking simply that the final order with respect to Mrs. Sarnoff be identical to the final order with respect to Mr. Sarnoff? For clarification?
This is
Yes. Yes.
Okay, done.
Is that what you're
The
asking?
final order, Michael, the final order in the case that's being directed to the city of Miami does not have the language of probable cause. If your question was, do I want the same thing here, that the final order does not mention probable cause? Yes.
I make a motion that the final order be consistent with the other order.
We have a motion that the final order be consistent with the other order that we gave in this case. Do we have a second?
Second.
We have a motion and a second. All in favor of granting a final order identical to the other order in this case, signify by saying aye.
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 We have 3 ayes, any opposed? Opposed.
Can we also make this very clear, though, that we don't want this to be I would hate to see this set a precedent as far as that anytime probable cause, we have a probable cause hearing, that we're inundated with people who say, well, we don't want that in the language in the final order and all of this. I mean, to me, it's just opening up a door that I don't want this to set a precedent. I think we found it for good reason, because we believed that Mr. Sarnoff was, had made the extra effort to try to find out, to get a legal opinion. It's not, that every probable cause hearing should
But we
drag out.
now, frankly, just found it in a case where Mr. Sarnoff did not, quite frankly, seek. Right? Back in November, we understood that the city council, that the city attorney spoke on only to the issue of Mr. Sarnoff's travel. That's what we discussed. And you're shaking your head no, but that's certainly not in the record.
Your counsel said that he checked with the city attorney's office, and they were aware that Mrs. Sarnoff was
They
going
were
on the
aware,
trip.
they did not opine. And
Okay.
then we made that distinction.
Okay. First of all, thank you. Second of all, I would like to offer the following, that my office work with this commission's office to have the county commission amend its code to include gifts to family members.
We will not concede that we don't.
Thank you.
There is one more case in open session. Mr. Morosky needs a few minutes to speak to
As
council,
the
so
council
we can go
provides.
into closed session, we can handle those.
So closed session, okay.
And in the closed session case that we'll handle first is 12-040. Council's present. I know, but I just want them to know the state. Council's present for 12:40.
Has the room been cleared?
So I'd like to make one suggestion, that you change your agenda
This
to
is
allow
not public
public comments afterwards, because to have public comments before a situation like this, when I do have public comments that are relevant, like I gave you people 100 pages of documents about this incident, none of what was told to you about only the wife was involved in this is true. Ron Nelson, his chief of staff, organized the meeting. I gave you the documents, the emails, all of the paperwork that proved that. They had a day and a half of vacation time over there.
Is this
Right.
public comments?
Again,
Yeah.
you had ample opportunity and you would not have been disadvantaged had